when the TRO was set to expire. Now today, after a hearing on this, the district court extended this again so we could give close consideration to all the pleadings submitted by the parties and complete a written opinion. Ah, gosh. So that means Hampton is still in power and he's still shredding files from his Outlook. He told Hampton that the board must grant the request for a stay unless the claim is inherently unreasonable. So they're saying, see, there is no discretion. That's beautiful. The Trump Justice Department now wants to know, what do we do with Hampton Dellinger? We ordered him fired. Judge Amy Berman Jackson shoved him back into the Trump administration to act as a Biden Democrat mole. Once he got back in, he filed to bring in other compatriots with him and take over certain branches of the government, even though he's been fired and Trump said, get out of here. So now what we saw is at the preliminary injunction hearing, Judge Amy Berman Jackson said, I'm not ready to make a decision on this yet. I need to extend this for 3 days. Trump has already been knocking at the door of the Supreme Court saying, guys, our Article 2 power is being insurrected by this Judge Amy Berman Jackson and by this fired special counsel, and we need you to do something about this. So the Justice Department Office of the Solicitor General just sent this one in. Acting Solicitor General Sarah M. Harris said the following: to Harris, Clerk of the Supreme Court. It's Harris and Harris in the House. Isn't that funny? I'm sure Sarah Harris, like, oh, what a coincidence. Dear Mr. Harris, on February 16th, all right, the government filed an application with the Supreme Court to vacate Amy Berman Jackson's restraining order, which was an injunction, in my opinion, that shoved Hampton back into power after Trump fired his booty. Then on February 21st, the Supreme Court came back out and issued an order holding the application in abeyance. So like, well, we got your letter, but we're not going to open it yet. We'll open it and we'll take a look at it after the hearing on the preliminary injunction. Of course, that hearing was on February 26th, the day they wrote this letter, yesterday from the date of this recording, when the TRO was set to expire. Now today, after a hearing on this, the district court extended this again until Saturday, March 1st. They're going, what the hell? So that she said, Amy Berman said, so we could give close consideration to all the pleadings submitted by the parties and complete a written opinion. Ah, gosh. So that means Hampton is still in power and he's still shredding files from his Outlook. Now, in the meantime, the harms to the executive branch from Amy have been even more concrete, says Trump. The same day that this court held the government's application in abeyance, okay, kind of like rubbing their noses in it, like the same day you guys could have solved this, just so you're clear, Supreme Court, thanks for not doing anything. Hampton filed administrative actions before the Merit Systems Protection Board, and he's challenging the 6 probationary employees, okay? So Hampton came back in, and then, like a cancerous infestation, is multiplying, brought back his other people in, saying respondent sought an immediate 45 stay of those firings, brought 6 people back, while my agency investigates further. Gonna go, now he's back in the Trump executive branch, investigating Trump, and announced he's considering ways to seek relief for even more employees. Okay, so this guy who got fired and thrown out is now in, and he's trying to bring back other people. Now, although Hampton had told this court he is an inferior officer that is subject to the MSBP supervision, because if he's an inferior officer, there's theoretically a different set of rules about his removal. If he's a principal officer, the argument would be he's just like the CFPB, the FHFA, or the Social Security Administration, all of whom were fired unilaterally by the president, and that was allowed. He told Hampton that the board must grant the request for a stay unless the claim is inherently unreasonable. So they're saying, see, there is no discretion. That's beautiful, because Judge Amy Berman Jackson yesterday, as we read through the transcript there, she was just saying, well, the special counsel doesn't have any power. He's just like a peon. He just makes recommendations. No, that's not what he says. He says that you must do what I say. And he sent that in a filing. An MSBP member promptly granted the stay. And guess what? Those people are back in. He then announced these stays represent a small sample of the probationary employees who have been fired when our work is far from done. Everybody should know we're going to continue to pursue these allegations of unlawful firings, and we're going to bring back the rest of the crew, right? The rest of his compadres. Now, in short, says Sarah, a fired special counsel is wielding executive power over the elected executive's objection to halt employment decisions made by other agencies. The MSBP, the entity responsible for this, argues they're deferring his stay request so long as the requests are rational. And by the way, the MSBP is also being led by a chairman who herself was also fired by the president, who also got shoved back in by another district court judge, okay? And we have not paid as much attention to that separate case, but it's the same thing. 2 boards, 2 firings, 2 district court judges, shove them both back in. The special counsel makes filings in front of the other fired person, right? One of the MSBP. So she's like, oh yeah, she's granting everything from number 1, right? It's collusion inside the government. It's an internal mole taking place that's happening, and they're affirming each each other, and the district courts are allowing it to happen. These developments, says Sarah, underscore the grounds for vacating this Amy Berman Jackson order. The government respectfully requests and asks this court at minimum to continue to hold the application in abeyance if you don't do anything else, if the court doesn't grant it now that they've extended it. Once the district court issues its final decision, presumably on March 1st, it may be necessary for the government to request further relief, because what she's probably going to do is, the TRO dissolves and she creates a preliminary injunction, which is like a new legal fiction, and then that is what gets appealed. And the plaintiffs in the underlying case were saying, as soon as that happens, Trump's application to the Supreme Court also evaporates, because his application was based on a TRO that will no longer be present once the judge enters her final order. I would appreciate if you would circulate this letter to members of the court so that they know, okay, whatever happens, we're going to be asking if it's necessary for us to appeal further, we will be doing that. Okay, so just let everybody know, like, this is what's happening, this is the timing, and that's going to happen. Now, Hampton said in response, we have no objection to holding this in abeyance. Once the district court resolves this, the TRO will dissolve and the motion to vacate the TRO will become moot, and then they can appeal the preliminary injunction. So Joshua, representing Hampton, circulated that letter as well, and we'll keep our eye on what the Supreme Court does on this. We want the Supreme Court to extend the same decisions that they created in Selah Law and Collins, which says that the executive branch has unilateral power to fire at will the heads of single-headed agencies like Hampton, like the MSBP, and all of these other branches. They are under the executive branch. The president can fire them. These district court judges should be told accordingly from the Supreme Court. We're going to be here when they do.